really wants the property, they have to satisfy the lien first. However, there is a problem regarding setting a precedent. Sweet went back a couple of weeks later and asked them to punch up his case number. Guess what? The case number had disappeared. The reason the case number disappeared is that after the judge ruled the county owned the property, subject to the lien, it became a case that goes against the corporate county bankruptcy public policy. Since Sweet placed a lien on his own property, he is the one who has to be paid off first, not the county. The county is now required to satisfy the lien before the county is allowed to take possession of the property. The property is probably not worth the price of the lien. This would not satisfy the true creditors, the international banksters. If the county pays Sweet off first, the city has to put on their records a $75,000 deficit. The true creditors wouldn't like that deficit. They certainly wouldn't like the fact that Sweet's clever maneuver had outfoxed the foxes. What if 100, 200, 1,000, or 10,000 people in your state would just put a common law lien on their property and then stop paying taxes? Then cited Sweet's case, it would set a precedent. Let the county have the property as long as the judge makes the judgment subject to existing liens. In this situation, the county would end up holding all this property but could have no use of it. No rent, no taxes, no permits, all deficient. The bankster creditors certainly don't like this scenario. The banksters don't want any cases administered except through the application of bankruptcy procedure. The banksters want your rights, privileges, and due process strictly administered by and through the corporate courts under their corporate public policy. International bankruptcy procedure. The international banksters and their unregistered foreign agents don't want any evidence on the record, showing how you can get out from under them. Any revenue collecting individual or agency such as the courts, judges, lawyers, law enforcement officers, and tax collectors who are attempting to take money from you as a private American must be registered as a foreign agent. If they are not duly registered and properly identified, they are involved in extortion treason against private Americans. How Sweet it is. As part of Sweet's maneuver, he filled out a financing statement using the UCC-1 form, whereby he put his wife and himself as debtors and creditors. Now, the legal situation is switched. The UCC-1 financing record Sweet filed with the state shows Sweet and his wife as being the parties of interest recorded with the state rather than the presumption that the international banksters are the parties of interest. There is an office within each corporate state, Secretary of State, that handles the Uniform Commercial Code UCC-1 claim forms. Since Sweet is listed on corporate state records as debtor and the creditor on his own property, his property can't be put up in any way for collateral against any debts claimed by the banksters. The reason is that the international banksters and their flunky agents now cannot prove that Sweet's property is debt property of the bank or the corporate county. The property cannot be put up against any debt claims until it is not encumbered by Sweet's lien. Sweet's property is not free and clear of all liens. The result is that for all practical purposes, the property is now Sweet's, being unencumbered by any further demand for payment of taxes. Sweet has not paid property taxes for many years. Sweet is now his own creditor, and Sweet is his own debtor. Therefore, the international banksters along with the county corporate thieves are knocked out of the stealing process. How sweet it is. Congratulations to Mr. Sweet. You may want to do it the way Sweet did. If you own property, you will need to get your deed and a common law lien, then fill out a UCC-1 form, then file it with the Secretary of State. This seems to be the only way for you to get out from under being a debtor of these bastardly corporate foreign international banksters. The judges have to know what's going on. The only way this scheme can work is to have all the lawyers and judges pledge to uphold the corporate bankruptcy public policy. The banksters just can't allow lawyers in a legal system who refuse to uphold the bankster policy. These renegade lawyers would have to be quickly weeded out. They certainly have a neat little system going here in America, the land of the free and the home of the slave. Attention, law student, you said you wanted to be a lawyer. Well, I hope you're reading carefully, because here is the legal system you're headed to serve, and serve you will. You said you wanted to be a lawyer so you can find out what oath they're taking, in secret, behind closed doors in solemn preparation for the business of the court as judges and lawyers. Now, you know the oath. The oath is simply to uphold the bankruptcy. If you want to be a lawyer and want to make a living as a lawyer, I can tell you this. They will weed you out at the very beginning if you don't bring in your paperwork under the bankruptcy procedures. If you try to defend your clients and try to help your clients, they will get rid of you. They will pull your license. So you spent all that money and time going to school under the disguise of helping people, and you're wasting your time. Without that license you can't go into a courtroom. I would think about this. Traffic citation regarding the UCC1 form. You can also file it against your car. Wouldn't that be a kick in the tail if you went into court for a traffic citation where you had signed without prejudice UCC1 207, and you had dishonored the traffic citation using the UCC in your procedure by having signed without prejudice and having gone home and sent in your dishonor of the presentment of the traffic citation? Now, let's say you are in front of the judge. The judge says, "What's this dishonor stuff all about?" The judge will not want any mention that the citation was issued under bankruptcy. He is afraid you'll mention the bankruptcy issue. The reason you dishonored the traffic citation is that it was issued to you under bankruptcy corporate public policy. He won't get into that. When you get before the judge, you just state you have removed yourself from the bankruptcy. Tell him your auto is no longer pledged for collateral against the debt. He'll say, "Oh yeah, what are you talking about?" That's when you hand him the UCC1 form that you filed with the state. This UCC1 form will show that you are the debtor and the creditor on your auto. Now what happens? The corporate county state can't collect on the traffic citation debt instrument. Why? Because, not that you're the creditor on the ticket. If they collect a $100 fine, they have to pay you the amount of the fine. How sweet it is. You're the creditor, aren't you? People have done this. Of course, there is no record, no paper trail. In such cases it is not cited. The corporate banksters' agents, clerks, lawyers, judges etc. take the information out of the records as soon as you beat them at their own game. Here is what I think happens in these cases. The American Bar Association is a franchise of the Lawyers Guild of Great Britain. The American Bar Association is not concerned primarily with what happens in any case on the local level. However, when a case leaves the local level, by that, I mean the state court, city court or the justice of the peace, or even the federal court, and goes to the appeals court, it would appear that the American Bar Association takes notice of the case. It would seem that the American Bar Association must have an agreement that any action brought on an appeal must be reviewed by the American Bar Association. If this is true, it would make sense. How else would the American Bar Association, a branch of the Lawyers Guild of Great Britain, which is the legal arm of the Rothschilds dynasty, be able to monitor and administrate the corporate bankruptcy? It would appear that the American Bar Association would be compelled to review all appeal cases and to make certain any case brought under common law or the constitutional law that would expose the bankruptcy would be immediately stamped on the back that this case is not to be cited or published. I believe that this is the stamp origin and purpose of the stamp message in such cases. The Justice Department may be able to do that in Washington, D.C. I can't see where any judge or lawyer could have the authority to stamp or label the case as one not to be cited for future cases. I think that is an official stamp from the American Bar Association. The bankruptcy accounting system now. Joe, law student, if you're still attending classes and you have a good professor, ask him her about just where the stamp comes from that you've seen on many cases. Just who put it on the paperwork and just who authorized the citation restriction. Just who is tampering with the law. There is one thing certain. The creditor and or his agents are watching these cases very carefully. The creditor and his agents must balance their books. When you think of the IRS, be aware that the IRS is an agent of the creditor, the corporate international banksters. This is just one of the banksters' stateside agencies. The General Accounting Office, GAO, is another agency they use for this country. This is where all the accounting goes to keep track of